Barev, Dobry den, Gamarjoba, Bună ziua, Ruj Bahair, Dobry den, Hayarli Kunar. I am Georgiana Takuc, a member of Drbf Board of Directors Region 2, representing Europe, and the country representative for Romania. And I invite you today to our webinar, part of If It's Thursday is Drbf Day, webinar series of Drbf Region 2. Our discussion topic today looks at how to best make use of the dispute boards in our region. And as you just heard me, our speakers will share experiences and examples from Armenia, Bulgaria, Georgia, Romania, Tajikistan, Ukraine, and Uzbekistan. Our speakers today are Boyana Milcheva, the Drbf country representative for Bulgaria. She is a partner at Dimitrov Petrov & Company law firm, heading its construction law and tax law practice groups. She specializes in construction, real estate projects and PPP, tax and corporate law. Boyana is a regional influencer and a prominent expert who represents and advises companies in major real estate and infrastructure projects, financed by the European Cohesion and Structural Funds, as well as by government and private funds. She is recommended as a top expert in the area of construction law by the most prestigious legal guides, Who's Who Legal, the Legal 500, Chambers Europe. Nina Tsaturova, the Drbf country representative for Georgia, is the head of legal and director at Intelligent Solutions, a multidisciplinary construction consultancy firm based in Tbilisi. She has a diverse expertise and experience of working on local and international construction projects of different nature and complexity. Nina specializes in construction law and dispute resolution and deals with construction disputes and contracts. She is experienced in the use of FDIC contracts and advises contractors, employers, and governments on drafting and negotiation construction contracts, claims management, dispute avoidance, and dispute resolution in all forms, including dispute boards, mediation, arbitration, and litigation. She is listed on the FDIC President list of approved dispute adjudicators and UK adjudicators list of dispute board panel members. Dr. Alexandra Marusheva is a member of the Drbf based in Ukraine and a legal consultant and the director of her own law firm. Alexandra has over 16 years of legal experience, is holding different positions either for an employer, contractor, consulting engineers, or NGOs, and also as an expert within working groups for drafting of legal acts. Alexandra has experience in dispute resolution and dispute avoidance in civil construction projects financed by various international financial institutions, state budget, or investors' private funds. She contributed to the Ukrainian translation of the FDIC guides under the FDIC license agreement. Karen Arustamian will hopefully join the Drbf soon. He has a master's degree in law and science and has 20 years experience in construction contract management, procurement, and construction law. He is a construction contract management and procurement expert with Technocrat Legal. He has worked in Armenia, Georgia, Kazakhstan, Uzbekistan, Belarus, Russia, and Libya. Karen is training on contract management, procurement, and construction law, and is a guest speaker at many events on these topics as well. Last but not least, Sina Velioglu is the Drbf country representative for Uzbekistan and Tajikistan. He is the regional director for Temelsu, a Turkish international engineering company with a history of working in development projects, mostly in Central and South Asia and Eastern Europe, funded by international financial institutions. He provides intermittent short-term individual consultancy services to the World Bank in various countries. He is experienced in management, procurement as per the IFI's guidelines, FDIC contracts, and alternative dispute resolution. Sina is a civil engineer with a Bachelor in Science from Middle East Technical University, Ankara, and a Master of Science in Construction Law and Dispute Resolution at the King's College, London. Well, now that I've introduced you, our speakers for today, I would like to introduce you to our topic, the case for dispute boards in Central Eastern Europe. And I refer here to the geographic continental Europe, right? And I would like to start with the conclusion by telling you that the dispute boards are a cost-effective project management tool. There is no doubt about it. And numerous studies have proven it over and over again, but with a caveat, only if parties know how to make the best use of it. You would find much more about this, about the business case for dispute boards from the chapter 2 of the Drbf Dispute Boards Manual, available on Drbf website. Today, we're aiming to share our experience, whether good or bad, and to give you some examples. And we'll start our discussion by looking at those countries with longest experience in using dispute boards in the region, Romania and Bulgaria, and how they mainly made use of the resolution function of the dispute boards, employing rarely the prevention function vested in the standing dispute boards. We will then continue with Georgia, which has quite an interesting approach to dispute boards, and follow with Tajikistan, Uzbekistan, and Ukraine. We will then conclude with Armenia and how its legal framework is suited to embrace dispute boards. Hopefully, we'll be able to convince you that if all parties know and understand how dispute boards work, we'll be able to employ them and make the best use of them in the interest of the projects. We'll invite you to put your comments and questions in the Q&A section. And just to tell you, we are scheduled for an hour, but should we have very many questions and you should wish to stay a little bit longer, we could go for some extra time. So this being said, I would like to start with an example of how not to use the dispute boards, the Romanian experience. And saying that brings back quite a lot of memories about the time when the Romanian contingent was having the biggest number of delegates to Drbf conferences, and the Romanian experience was a regular topic on the agenda. Well, dispute boards were introduced in Romania via FIDIC contracts sometime around 1996. Some colleagues say that even before, but I haven't been able to find the case studies to prove it. Through the FARE program, and yes, we were using FIDIC 84 and its supplement, and this way, DABs became mandatory for use in the public sector. They had a great start, and unfortunately, everything went south pretty soon. And the biggest issue that impacted in a negative way the perception of the dispute boards was, to my belief at least, the lack of training of the public employers, or more correctly, of those actively involved in implementing the contracts, and also afterwards, their retention by the employer. And that lack of training was in regards to the FIDIC contracts in general and to the dispute boards as DABs in particular. The employers had and gained little knowledge about the functions and the role of the DABs, about their scope, about the way in which they should work or should be used during a project, about the way in which a case must be construed and presented to the dispute board. And I include here the way in which they were not able to bring before the DABs or to convince the DABs about the limitations, mandatory limitations to that exist in the public sector when analyzing a dispute and issuing a decision. Another issue was the fact that the standing DABs were not used for the avoidance of the disputes, and many of the DABs' decisions were in favor of the contractors, and that deepened the negative perception that the DABs are not good for the employer, that they cost too much for the benefit that they bring to the table. And all this, together with a lack of minimum relevant knowledge about dispute boards or DABs, in this particular case of the lawmakers this time, led to an improper regulation of the FIDIC contract with uninspired modifications that were fructified at maximum by the private contractors, and to an improper use or removal even of the DAB clauses from the contract, because whilst the use of FIDIC contracts was mandatory, the use of DABs was not. And at the level of secondary and tertiary legislation, and I'm referring here to government decisions and ministerial orders, which were adapting FIDIC contracts to the national legal framework, there was a routine to opt out for the ad hoc DABs or for even removing the clauses altogether. Another aspect was the fact that the dispute boards were new in Romania as an ADR method. And they came at a time where the mediation was heavily publicized and pushed, if you want, by the EU. And public employers have often complained about the fact that they cannot enforce or comply with the DAB decision because DABs were not regulated by the law, forgetting, in fact, that the same legislation which made the use of FIDIC contracts mandatory, those government decisions and those ministerial orders, made, in fact, the use of DABs mandatory, at least there where they were kept into the contract. Saying that, another factor that might have contributed in my opinion, to that negative perception was perhaps the way in which the construction industry, the private contractors, made no visible effort to educate, if you want, their employer and their own local personnel in what regards the DABs. The way in which they use the standing DABs only to solve disputes and not to try to avoid them or to prevent them. And the way in which themselves, they did not understand, or at least they did not recognize the limits within which a public contract works. And saying all that, I wonder if the contractors did not somehow contribute to the negative experience of the dispute boards in Romania. And I'm saying negative experience in particular referring to the fact that the standing DAB became an ad hoc DAB, or that the DAB procedure was completely removed, not only by legislation, but even by the employers themselves who had this option in their contracts via the particular conditions. Many times because of a fear of an abuse of the use of those clauses by the contractors. There was no more trust at all in the concept of dispute boards, in the dispute boards as a tool. And the experience went so bad, in fact, that in 2018, the Romanian government promoted a national standard contract that had no dispute boards at all. It does recognize as ADR methods, mediation and arbitration, but no dispute boards. Now, with the recent World Bank finance contract in the health sector, FIDIC 2017 and its DAAB took a first step into the Romanian market again, and DAAB clauses are intact and applied. Many of us in Romania have continued to advocate for the return of the dispute boards and for the proper use of the dispute boards in Romania. And we hope that this time they will be used properly in the interest of the project. And it is to this end that Drbf is organizing on 10th and 11th of March a complementary workshop about the administration and practice of dispute boards from the perspective of public authorities, dedicated to public authorities only. So this was a very brief story of how to misuse the dispute boards, and hopefully we have learned something out of it. And I would like to invite now Bojana to share with us the Bulgarian experience. Bojana, if you please.
Hello, everybody. Unfortunately, I have to echo Georgiana's words in saying that we are not much more successful in Bulgaria with dispute boards than the people in Romania, but on a smaller scale. But same mistakes and same failures. We hope we had some lessons learned, but we will see. Dispute boards in Bulgaria were introduced with IPSA programs back in the beginning of 21st century, 2000 and onwards. And this was the first time a kind of a multi-tier dispute resolution mechanism was introduced in Bulgaria. Was quite unfamiliar to the legal system. Not prohibited, it is permitted, but not familiar, not widely used, and still it's not well developed. We don't have enough court practice or arbitration practice, in fact, to explain how this mechanism could be used for a benefit. This being said, in addition to the fact that DAB's decisions are not enforceable per se in Bulgaria, as in many civil law jurisdictions, because they are not in the list of writ of execution grounds to allow direct enforcement, give you the background why the DBs were looked at with very much with suspicion. Add to this very inexperienced employers and their inherited reluctance to not to pursue a dispute to its very end. Here some Eastern European specifics are involved as well. Everyone is very much afraid not to be accused in siding with the contractor or have some interest in resolving the issue prior to the very end of dispute, led to the result that even the disputes which were agreed and included in the contracts, and this was very much the case in these big projects that took place in 2000 until 2007, 8, 9 even, were not used and their advantages were not used actually. Most of the times what we had was FIDIC yellow book contracts with ad hoc one-member DABs agreed, but even they were not explored. I'll give you a short example of a case I was part in, and it was an example of a total loss-loss scenario. How it shouldn't be done. Again, it's a FIDIC yellow book contract. Employer is a state-owned entity, infrastructural project, international contractor, and international engineer with a lot of experience in FIDIC contracts. But even with this engineer, the contract was ridden with disputes from a word go. The contractor was given plainly to see that referring disputes to the DABs will not end up in the employer giving effect to these DAB decisions. So they simply give up on that. And they didn't use even the ad hoc possibility to constitute a DAB. So in the end, the contract was terminated by the contractor, which resulted in a 6-year delay in completion of the project. There was a DB in the end because the contractor contested the final account given by the engineer. And miraculously enough, the DAB was constituted after the contract was terminated pretty quickly. This was a bit of a surprise. The DAB came up with decision within the 84 days term, also a miracle, awarding the contractor extension on time and cost plus profit. And it was very well-reasoned decision, plainly demonstrating that the contractor was indeed entitled to all of this. Of course, the employer did not give effect to the decision. They issued a notice of objection. And because this was prior to Prospero cases, this failure of the employer to give effect was again referred to DAB. This time, the employer delayed the appointment of the DAB for almost 1 year. During that time, the arbitration clause included in the contract expired. And when the dispute ended up in the arbitration anyway, after 3 years, the arbitration rejected contractor's claim due to lack of a valid arbitration clause. So in the end, we had a very disappointed contractor with loss of money who never returned to Bulgaria again. Very disappointed employer because they spent almost as much money for expenses as they owed to the contractor under the DIB decision. That the same employer refused to use FIDIC contracts or DBs for the next 10 years. So what we learned from all this was that DABs actually saves money and saves relationships, but you have to know how to use them, exactly what Georgiana said. What we hope is that we are slowly, but we are on a learning curve.
Thank you, Bojana. Nina, if you please.
I think I may direct participants to more positive experience of using the dispute boards, because
I was hoping
experience from Romania and Bulgaria is not so favorable. I will start my speech today with saying that in my perception, use of the dispute boards here in Georgia is quite successful. Of course, there are some negative examples which I will speak very briefly about, but the majority of the projects, infrastructure projects I'm speaking about, are using dispute boards very actively. The most active state bodies like roads department, like Ministry of Infrastructure, and many others are using them on the standing basis, I would say, not as ad hoc, but as the standing one. And the statistic I can present to you, like the first dispute board can be traced back to 2015, I would say. And since then, at least 25 dispute boards were in place in Georgia. And talking about the success of use of the dispute boards, I would say that according to my research, only one dispute board decision was referred to the arbitration. So there is nothing more to speak about the success of the dispute boards, rather than to say that only one dispute board decision was referred to the arbitration. That's on the positive side. On the negative side, I would say that there are still some employers, especially the private ones, and also some state bodies, probably which are not so in favor of the dispute boards. And I would say this is just about the lack of knowledge that Georgiana mentioned and Bojana mentioned as well. This is probably the main reason of not using them properly. I would talk about one of my negative experiences with the dispute boards from the employer's perspective. So this was a water project. The employer was a state body, and there were some disputes between the contractor and the employer, and the contractor asked for the employer to nominate the dispute board. So this nomination procedure took about 6 months at least. There were no answers from the employers, nothing at all. And then there was an appointing body stated in the contract, and the contractor referred to this appointing body, and the appointing body nominated a dispute board. The proceedings started. The contractor presented its referral. I was representing the contractor at that time. And then the employer asked the dispute board to refuse to continue with the dispute board proceedings, stating that the appointing party breached the procedures of appointment because the member of the dispute board should have been from the list of accredited mediators in Georgia. So here is the hell started because, of course, the member of the dispute board refused to suspend the proceedings, and then the employer referred this case to the court. And the court, and it was interesting that the case file was submitted against the appointing body of the dispute board, not against the dispute board member itself or against contractor, but against the appointing body. So it is very interesting what the court will say, because it's upon request of the employer, it also issued the interim injunction saying that the dispute board member cannot proceed with the dispute board proceedings. So, and these proceedings last for almost more than 2 years from now, and still no court hearing is scheduled, and still we are waiting for it very eagerly, because it would be very, very interesting to hear what court would say. Like on one hand, it is using the interim injunction stopping the DAB proceedings, and on the other hand, I can't believe that the court will be so confused to say that the dispute board member should be appointed from the mediators, accredited mediators list. The main reason from that, I would say, just the lack of knowledge about the concept of the dispute boards. Probably this is the main reason. And there may be some other reasons, but probably this is the main one. This is just very, very brief story of the dispute boards, of the positive part and of the negative part. That's my experience.
Yes, I remember that we were speaking last year in March about the court decision, and actually looking at a webinar to discuss it and dissect it and see what's happening. So still not there
no
yet.
Hearing. Like the assistant of the judge, I'm calling her, I think, every week, and she's saying, no hearing, no hearing. So.
Thank you, Nina. Sina, if you please, share with us some of your experiences.
Yeah, so as probably with elsewhere, the dispute boards are very new in Uzbekistan and Tajikistan, and generally in the region. There is, as also my colleagues mentioned, there is quite a lack of knowledge. What is it? So when you discuss with the employers and the contractors, and the general question is, what is a dispute board? What is it at all? And sometimes employers say, oh, we have the engineer. Isn't the engineer supposed to resolve the disputes? So we generally try to explain to them that's a different thing. So engineer now is not a impartial party. It's the like the employer's agent. So there should be another impartial body who is resolving these disputes. First, both parties, generally the employers, are very hesitant and skeptical about using these. Why should I pay money to somebody to solve my disputes? That's the general motto. But when they mandatorily start using it, we saw that they start liking it. For example, in Uzbekistan, 65% of the applications to the dispute boards are from the employers, and 35% are from contractors. And according to statistics which Uzbekistan Association of Consulting Engineers made, 94% of the decisions did not go to arbitration. Only 6% went to arbitration. I think worldwide, according to Drbf statistics, this is only 2%. So we can say it is more or less successful. And against all this skepticism, parties are starting to use this because it is becoming more and more mandatory every day. So in 2017 FIDIC, which is now being used by the World Bank, in which some of the contracts we used to, it is one of the commencement conditions. So the works cannot commence before the DAB is constituted. So all the parties are trying to learn what dispute board is, how it works, etc., etc. And I think it is expected that this will boom in the coming years. And like people didn't know who the engineer was, like 10, 20 years ago maybe, and now everybody knows who the engineer is. I think after 10, 20 years, everybody will know what dispute boards are and what their function is. And I expect that it will become something like in a UK statutory adjudication. It's like the statutory adjudication, it will become more common in the region. At the moment, neither in Uzbekistan nor Tajikistan, there is no legal framework, but some, I think there are studies and thoughts coming about that. And I think there will be some studies regarding legal framework so that dispute board decisions are enforceable. So that's more or less all I can say at the moment. If there will be any questions, I'll be happy to answer.
Thank you, Sina. Well, I hope it's going to be statutory prevention rather than statutory adjudication directly, but I know what you meant. You referred to the dispute adjudication boards from the FIDIC contracts. Alexandra, if you're ready to share with us the Ukrainian experience in so far.
Yes. Actually, we should take into consideration that in Ukraine, as in Bulgaria, and maybe in some kind like in Georgia, but I think that the project implementation in Georgia are more wider, have more wider range, but still the dispute boards wasn't used so often in Ukraine, despite some reduction in the total amount of international financial institution. Fundings last 2 years, I guess, a fairly large number of civil engineering project financed by this IFI implemented using the FIDIC contract form, and as a result, we have the DAB kind of DB. However, a fairly large number of contracts provision are modified at the discretion of the employer and contractor, often without sufficient experience of the application of FIDIC contracts, forms, provisions by the parties and by their legal departments and house lawyers. So therefore, it may lead to missed contract procedures, to the gray zones of the contract, which in its turn increase the risk of possible disputes and provisions that are not complete enough to to use it more efficiently and to resolve this. There is no estimated number of submitted claims for the consideration of dispute boards in Ukraine. However, there are disputes in the project in the road construction. So we have the information about the DAB using in road construction projects, in district heating, water supply, and renewable energy projects. But still, parties of disputes in Ukraine are not interested in disclosing not only the details of the dispute, but also the fact that the dispute took place in the project, and they consider it as reputation loss or something like that. So this makes it difficult to obtain, to get more reliable information on the number of disputes, the amount of claim, the decision of the boards, and other information. Ukraine also has an experience involving the adjudicators from the FIDIC president's list in dispute over the project implemented in Ukraine. However, the parties of the dispute in Ukraine at the moment in their total number do not oftenly understand that this method, this tool, the dispute resolution can be used with significant advantages for the party of this dispute. So from the negative point of view of some examples, cases, I have had a case where contractor do not know nothing about the client procedure. It seems that they do not know nothing about this part of contract provision as well. And they asked to develop the step-by-step procedure to do how to do it in proper way because of missing contract provision as well. And their small experience in such implementing of such kind of contract documentation. Practically, I have the similar to Armenian experience, which Georgiana mentioned, that in Ukraine we have the projects with the contract documentation under FIDIC Red Book, but standing DAB becomes an ad hoc DAB as per Yellow or Silver Book, only when this dispute had arose. So the conclusion is that our task is to convince to make the information to be spread, to be promoted, about the main advantages and benefits of this method or mechanism of using dispute adjudication board or DB as whole. Thank you.
Thank you, Alexandra. So, and also, you know, be careful when you modify your contracts, especially a FIDIC contract that goes step by step, and the modification of one clause has effects on all the rest of them. Yes, not a very good start, and everybody had high expectations from Ukraine, learning from the rest of surrounding countries' experience. Thank you very much. Karen, what can you tell us about dispute boards in Armenia? And everybody, can you please have a look at the questions that appeared in the Q&A and prepare for the answers. Karen, please.
Okay, so I know only about 3 dispute boards that have taken place in Armenia, and only one of it has gone to arbitration. And in my talks that I have during between our specialists, I noticed that Armenian employers, even if they are state bodies, they generally accept dispute board resolution, and very rarely are dissatisfied with it. And this only case, which I know, which has gone to arbitration, is some very special case when the parties became enemies, and each party wanted to see the other's blood. And as far as I know, it is under arbitration till now. But anyway, this is my statistic, which I have. And I was going to speak about implementation of dispute board decisions under Armenian law. I have prepared a small PowerPoint presentation, and I will try to share my screen with you. Just a second, please. Can you see it?
Yes, we can. Perfect.
Okay. So Armenia is civil law country, and we have everything regulated by codes, laws, other regulations, and we have no specific definition of adjudication in our law. Anyway, it is not prohibited, and we use it. A civil procedure code, which provides all the details how to deal with civil proceedings, has provisions for, they say, extrajudicial proceedings, and mediation and adjudication fall under that definition. So both are recognized by civil code, and if you are an adjudicator or mediator, you will feel quite comfortable, because the civil procedure code it implies to the courts not to take the claims for examination if there is a extrajudicial clauses provided by the contract. So if you bring a contract which is under the dispute to the court, and there are extrajudicial clauses for dispute resolution, court for sure will return this claim until the parties did not pass all the proceedings provisioned by the contracts. Even during the examination by the court of a claim, if the court finds out that there was a extrajudicial proceeding provision, so it will stop the hearings and will send the parties to resolve their dispute by extrajudicial means, for example, by mediation or adjudication. Also, civil procedure code provides such a good instrument for adjudication, like application, like pre-trial security measures. When you ask the court to arrest the other parties, let's say for money or other property, until the proceedings are resolved. If it means that the claiming party can apply to the court, saying that we have a dispute with the other party, it is under extrajudicial proceedings, and we would like to arrest this or that property until the hearings are resolved. This is also provides quite good instrument to the adjudication, and also let's go to the other slide. This is the last one. And when the parties have resolved the issue between themselves by mediating or adjudicating, and both are accepting this solution, they, of course, they sign settlement agreement, and a party can, it is not obligatory, but a party can verify this decision into the court for being able to enforce it. Let's say to apply for service of compulsory enforcement of judicial acts to confiscate this or that property, let's say. So quite, I would say that law provides quite comfortable for adjudication and mediation, even though we do not have law on adjudication. And when you asked me to translate adjudication to Armenian, it was very difficult for me, because we even do not have special term for that. And
thank you very much, Karen.
But it works.
Well, quite educational to see that board decision will be enforced should there be required to, if the parties are not willing to execute it by themselves. Well, I would like to start the Q&A session now, and we'll go in the order of them being addressed. The first one, it would be interesting to hear the speakers clarify what happens in their public contracts when there is no dispute board, and whether the non-dispute board contract disputes resolve more easily and less cost, or do the disputes remain and lead the parties into litigation and or arbitration? Who would like to start? Okay, I will start then. In Romania, at least, the FIDIC contracts who have no dispute board clause would have had either arbitration or court options to choose. No, they were not more effective, and no, they were not more easily to solve. They would lead to years and years of, some of them are even now on the roll, 5, 6, 7 years later. Similarly, the new contracts, the 2018 introduced contracts do provide for an option of arbitration or litigation, and also have introduced mediation as a mechanism during the settlement agreement period. So that's the Romanian perspective. Who would like to continue?
Again, very similar in Bulgaria. Yeah, there are two options, arbitration or state courts. Most of the times where a foreign contractor is involved, there is an arbitration clause, but referring to the Bulgarian arbitration institution. The disputes remain, and most of the times they are very lengthy, especially if they end up in the state courts, because they end up in Sofia state courts, where there are a lot of cases, and you can spend 2, 3, or 4 years just in one instance. So the answer is clearly no, the lack of DBs didn't lead to any expedition or to lack of disputes, just the contrary.
I may also add,
Please,
if I may, like the same experience as in Bulgaria and in Romania, you have two options, either going to the state courts or arbitration. And I would say that maybe at the first sight, going to court may seem less costly to the parties, like because the state fees, the maximum state fee, for example, in the first instance is maximum around $1,500. So this is the only fee you will have, but like the legal costs and the things like this, and also the time code related costs that you will have, because it's the same here in Georgia. If you go to court, you may spend around 2 or 3 years just in one instance, and you will not get this money before you have the court decision. And saying about arbitration, this you also know how big may be the cost of arbitration, including the cost of experts, including the legal costs. So I would say that the DB option would be much more less costly compared to the litigation or arbitration.
Yeah,
for instance, may I add also?
Yeah, just a second. Public authorities here generally are tax exempt in state courts, but still they have to pay for legal services and stuff. Mm-hmm. Please, Sina.
Yeah, in one contract, disputes got very complex, and it got to the stage that one of the parties was going to do arbitration. At that moment, the other party was continuously saying, I wish we had dispute board here. So if you like, dispute board is like a vaccination in the COVID era. So some people don't want to get vaccinated, but they wish they were vaccinated when they get sick. So dispute board is like the vaccination before you get sick. So people start thinking about that when they really get sick, but it may be too late. So it's not less, not having the DB is not less costly, I would say.
Thank you. A very, very contentious topic, the vaccination. I prefer not to get there. So
questionable metaphor.
Not even metaphorically, no. Because there, anyway, it's just a lot of debate on that one, please. If no one has, oh, Karen, please.
Yeah, the same as in Georgia is in Armenia. So if we do not have no DB, no arbitration clause, the claim will go to ordinary just state court. But law allows to establish, to rearrange the contract and to agree for DB or for arbitration after the dispute arises. Mm-hmm. And the same with costs. Everybody thinks that state court is cheaper, and nobody thinks that it lasts long. In Armenia also courts are overloaded by work. So I had a very easy claim in the ordinary court, just 2 hearings, but it lasted 1.5 years.
Mm. So everybody has a perception that is cheap, but they don't realize the impact and the lengthy duration on the project and how much it's actually costing in the very end on the project and on the parties. Well, thank you for the first question. I would like to go to Gordon's question. Can the speakers also report whether there is evidence of any use of the ICC dispute board rules instead of FIDIC dispute board rules? Well, in Romania, to my knowledge, in public contracts, there is no ICC DB rules at all in those FIDIC contracts that we're using dispute board rules. In the private market, I'm not aware, but I doubt we have used ICC DB rules if we used FIDIC contracts, and FIDIC contracts would be the most used in the private industry as well here. I will keep an eye on it, and if I find anything, I'll let you know, Gordon. So anybody knows about the use of ICC dispute board rules in their countries?
No.
Thank you. Another question. Several speakers have commented on the lack of understanding of the dispute boards. It would be interesting to learn the speakers' views on whether the DRBF should try to organize training for the country's consulting engineering associations. Also, what about a similar DRBF effort with the country's bar associations of its lawyers? Well, I don't know who's asked that question, but I tend to presume that is not a member of a consulting engineering association. I could say for some of our well, actually, for most of the countries in our region, in terms of consulting engineer associations, they do organize quite a lot of training, mainly FIDIC training, but also sometimes in cooperation with DRBF organized dispute board training. In terms of bar association and other legal organizations, some of the countries do, some less open to cooperation with third parties entities. I am not aware of a bar association, though, who has refused to recognize, for instance, a DRBF CPD training, given there was a question earlier about CPD. This is an informational webinar, not a workshop, and DRBF does not issue CPD certificates for this, but we do issue CPD certificates for workshops, for training workshops. And I could tell you that the Romanian Bar Association accepts and acknowledges them, because I have used mine ever since 2009, and they've always been recognized. Anybody would like, for instance, Nina is also a member of the board of the Georgian Consulting Engineering Association, and she could tell you that they do organize quite a lot of training, not only by themselves, but also together, DRBF.
Yes, some people, some attendees may remember this conference back in 2018 March when this COVID madness started. So this was the first conference, the mutual conference, the joint conference together with Drbf and Georgian Association of Consulting Engineers. And we also did the workshop of administration of the dispute boards, and I would say that despite the Corona madness, the conference had a very good attendance, but of course the Corona travel matters really was very stressful. But we would be happy to have another conference or another workshop here, and I think it's a very good solution to spread the knowledge among the users and also the government bodies. Thank you for your question.
Thank you. And I believe that even Bojana could confirm that she was part of the Bulgarian Consulting Engineer Association. She's still a member of it, but she was part of their board. Alexandra is part of a Consulting Engineering Association in Ukraine as well. So we all been very active on all fronts and try to share the knowledge with our colleagues.
And just for your information, in the next spring, we are also planning a training with the Uzbek Association of Consulting Engineers in Uzbekistan. We are holding discussions for that.
We are struggling a bit with the state-owned authorities. The association and bar associations, they're actually willing to learn, and there is interested, but in state entities, it's trickier.
Well, I think it depends. I know there has been a lot of training with state authorities, and I know that actually it has been done for a very long time. The problem is the flux of personnel. Those who were trained have been left for the private industry. Once trained, they were, good resources for either private employers or private owners, and most of them have left. There are very few people nowadays left in the public authorities with experience who have been trained directly by either Drbf or other associations in dispute boards. One question, I'm not sure I understand it correctly. Boris, if you would like to come online and explain a little bit. You ask, can you inform us yearly or one project dispute board solved issue numbers? I'm not sure I understand what you mean. If you could come online and explain it to us, please. Boris?
Hello?
Hello, yes, we could hear you.
Yeah. Hi everybody. So I'm contacting from Mongolia. Actually, we don't have much with the contracts, don't have much experience. So even we don't have the local dispute boards in here. So that's why, sorry, my question might be, I don't know, not so serious or simple, but anyway, we don't have much knowledge about PDB here. And just for us, interesting if, we have dispute board, so we have all the claims and disputes we are solving for one project. Maybe there is numbers, let's say yearly we solve such problems or such disputes per year. Not.
You mean statistics?
Yes, some statistics, numbers, because we don't have here any. So
okay, there are several very good statistics that you would find on the Drbf website in the library. I have some here, and I'll I will give you some data, but you could find them on Dispute Resolution Board Foundation website. And there's also an Excel folder containing not a very up-to-date, put it this way, and not very comprehensive. Most of the people added the information, but we're still adding, and it's not been double verified completely. We are reviewing that information where you could find several thousand projects around the world using dispute boards and how they are used around the world. I could tell you, for instance, in terms of Drbf effectiveness, and this is a study of 2017, not in Europe, in North America and Australasia. And it is about dispute board effectiveness. So we're looking at standing boards and ad hoc boards in about 107 MDBs projects, 37 bilateral loan projects, government projects 47, private projects 11, other 29. In terms of dispute avoidance, it took place in the majority of them, and we had 59, 1,900, about 125 boards, out of which they were issuing 280 opinions, 283 decisions, and from all this huge number, only 3 ended up in arbitration. So they did have an effective avoidance function. In terms of those ad hoc boards, we had about 185 boards appointed, about 42 opinions issued, about 143 decisions, and out of 185 ad hoc boards, about 26 ended up in arbitration. So you tend to have more issues with the ad hoc boards rather than with the standing boards, who obviously are more familiar with the project, more time to learn and keep upgrading their information regularly. So I hope that helps. But you do have several statistics in our library, so by all means, please consult it.
Great, thank you. And
welcome.
Sorry, yeah. Are there any Soviet, like pre-Soviet countries? Are there any numbers or suggestions, because Mongolia also belongs to Soviet countries?
Well, as you well know, we have here several ex-Soviet republics, so they all have used dispute boards, and to the better or for worse, they do have. We are all having, put it this way, we all come here from former socialist communist type of legislation on a civil law jurisdiction. And we have a legislation that allows contractual mechanisms to be agreed by the parties. And dispute boards are largely a contractual mechanism, right? Therefore, there are very few, if any, impediments in national legislation to the use and implementation of dispute boards. There is a certain difficulty in implementing those decisions on the part of the public authorities, because they are very heavily regulated and they do have very strict rules because they administer public money. And in public money, I include government budgets, local budgets, and all sorts of loans and grants from international financial institutions, MDBs or EU. So in theory, everything is possible. In practice, I think it's a matter of educating our staff, educating ourselves, and learn to work together. and select the right dispute board members, I would say, because if you don't trust them, if you do not select what you actually, people that you actually trust, how could you rely on their advice? Boris?
Great, thank you.
Thank you.
Yes, thank you.
Thank you. Hamish, hopefully the particular problems can be overcome as people get more confidence in what is the best way of resolving disputes. Thank you, Hamish. Anyone would like to add anything or any other questions? Yes, someone put his hand up. Let me find out who. Christian, please, if you would like to come on screen. Thank you. Hello, hello.
I hope you
Christian?
can hear me.
Yes, we could hear you now.
Oh, good. That's good. Thanks for the opportunity. I would like just to share with you 2 projects that I'm currently involved in. We took about 4 years to get dispute boards on those 2 projects. We have now managed to get both projects, the dispute boards going, and we had first sessions with the people, and there was an incredibly positive approach to presented by the dispute board members, which was actually also very well received by the initial party which were against getting the dispute boards in place. The comment that I heard from the one party, they said, I lost my fear for dispute boards just because of the way how the dispute board presented themselves, make an effort for the people to understand that they are there to assist, to support, and to prevent and avoid. And I think if that message can get through to people, and then that message is also implemented during the process, can help quite a lot for the attitude change that we are looking for here.
Okay. Can I just ask you where those 2 projects are located?
Yes, one is in Pakistan and the other one is in Ethiopia.
Okay. And you have a dispute adjudication board in Ethiopia or a dispute review expert board?
In Ethiopia, we've got a FIDIC silver book, so we've got a DAB, but we have converted that to a standing DAB.
Okay,
and
interesting.
In Pakistan, we've got a pink book. So we've got the standard FIDIC pink book, 2010 version. So there we've got the DB, which is standing anyway.
Thank you for that. It's interesting because Ethiopia is mainly using dispute review boards rather than DABs as such. So that's good to know. Thank you for your intervention, Christian. We have gone a little bit over time, and if there are no other questions, oh, okay, thank you, Luis. I would ask, oh, sorry, there's one more question. From Josephine, what advice could you give us with regard to proper and sufficient preparation of dispute board members with regard to differentiated application of civil law and common law in a particular dispute? Ooh, that's fun. Who would like to go first? No? Okay, that's not fair. So, in terms of...
Right.
Yes, okay.
Choose very carefully the DV members. And what we say, it's best to have 2 engineers and 1 lawyer. If this is the best composition, then please pick up a civil law or common law lawyer when going ahead with the DV composition. But if you have a single member DB member, then it will be tricky. Make sure you have the proper consultants to make the proper submissions.
Yes, I would only add that you would need to look first at the majority of your issues, if they're mainly technical or if they're mainly contractual. And I'm not blaming anyone, and I'm making no accusation. And we started with Anglo-Saxon common law dispute board members in a civil law country. And the issue I've seen was the differentiation into the public law as we know it and the public law as they know it, or as they practically do not have it in terms of administrative law. So here were where I saw most of the issues. In terms of how the DBs that were active here to start with in early stages, I could say they were brilliant, and I could say that we've learned a lot from them. In time, though, we started to look for the more cheaper option, if you want, and that's perhaps when things started to squeak a little bit. But it will all depend of the, I guess, the main jurisdiction of the country where the project takes place. I would suggest that you look at that one in particular. Anyone else would like to add? Okay, then I would like to ask each of you for a conclusion. What do you think the dispute boards are the right tool for our projects in our region? And I would like to start with Bojana, please. Same order, everybody.
I really hope we have learned a lot already. There is a plan for some reorganization and development of our construction legislation. And there's talks about introducing a standard forms of contracts. And we very much hope and advocate this to be 2017 FIDIC books. And we very much advocate for having a standing DAABs, so we can enjoy for the first time the luxury of dispute avoidance during our projects. We very much hope this time we'll done it right.
Thank you, Bojana. Nina?
Well, I will be very brief. Considering the positive experience of the dispute boards here in Georgia, I would say that definitely, yes, this is the right project management tool here in Georgia.
Thank you. Alexandra?
Yeah, so we do hope that in Ukraine it will be more oftenly used as a tool or mechanism with the benefits and advantages to save costs, to maintain the business relations and minimize the risk with avoiding of litigation.
Thank you, Alexandra.
Thank you.
I would like to say that people generally tend to be skeptical about things they don't know. But the more they start to know about it, they become more familiar with it. They start liking it. It is also true for dispute boards, especially when you are giving authority to somebody else to decide about your disputes. But the more they are used, they will become more common. And I think parties are starting to understand the benefits of it. As I said, it's like a vaccination. So I think it will get more and more used, and the benefits will be understood better in time.
Thank you, Sina.
Thank you.
Karen?
You know, I have both technical and legal background. So, and during my experience in construction, I'm collecting fail causes. I have very beautiful collection of fails, of project fails, And these two backgrounds helps me to understand where the failing cause is. And I see that dispute board resolves many issues and prevents from failure.
Thank you, Karen. Well, I will conclude by saying that all projects deal with technical and contractual problems, and however, the major issue is always a lack of proper communication between the parties and the tendency of finger pointing rather than solution finding. And that's where the dispute boards help parties communicate properly, make them understand that any and all problems are project problems, not personal problems, and they must be solved together. Learn about dispute boards, choose your dispute boards members carefully, because if you don't trust them, then the process is damaged from the start. Use your dispute boards in a timely manner, keep them informed, call upon them, and make the most of their prevention function. And this being said, a warm thank you to all our speakers and to all of you who have joined us today, and looking forward to meet you next time. Please have a look at Drbf event calendar, and see you soon. Thank you.
Thank you.
Thank you.
Bye.
Bye.
Thank you. Bye.